Hi everyone, and welcome to this webinar on abuse of process. I'm Martin Ferguson, a junior barrister at Farrar's building with a mixed civil practice. This is the latest in a series of webinars with Mr. Jake Rowley's rousing dissection of fundamental dishonesty last week being a tough act to follow, but I'm going to do my best. There'll be an opportunity for questions. You can ask them at any time via the question tab on your screen. I'll do my best to answer them at the end of the webinar, but you can ask them at any time. All of the previous webinars are available on Chamber's website. So if you just head to Chamber's website, you can access them at the Knowledge Base tab. This webinar will be there too. So if you have any issue with it now, you can come back to it and you can see it in due course. I'm going to spend 30 minutes or so focusing on abusive process applications, trying to bring some life to the topic, and if there are any questions, I'll do my best in the remaining time. There are various categories of abusive process, and I'm going to focus on those which tend to present themselves more frequently, as well as on the nitty-gritty of making or resisting applications. When considering abusive process, we're primarily concerned with the prospects of achieving or resisting strikeout pursuant to CPR 3.4 2b. So that has to be our starting point. The court may strike out a statement of case if it appears to the court that the statement of case is an abuse of the court's process or is otherwise likely to obstruct the just disposal of the proceedings. Now, the important point to note here is that there are two stages. First, is the statement of case an abuse of the court's process? And secondly, if so, should the court exercise its power to strike out the statement of case? I'm going to deal with 1 and 2 back to front because the second question is more simple. It comes down to a basic exercise of the court's discretion. So whether the court should strike out an abusive statement of case is a discretionary matter for the court. That means that strikeout has to be supportive of the overriding objective. So when making or responding to an application, it's important not simply to focus on what is relevant to the matter being or not being an abuse of process, but also to consider each aspect of the overriding objective and to consider what you can say in your statement about that. And key within that, and this is something which the White Book reiterates, and so it's something which most judges will have in front of their nose, is the proportionality of the sanction. Striking out should be the last option. If a less draconian sanction is available and appropriate, it should be used. Now that obviously makes strikeout a high hurdle for an applicant. There will probably be a less draconian sanction available, but bear in mind, just because there is a less draconian sanction, that doesn't mean that that sanction will be appropriate. It's easy and wrong to conflate the availability of a sanction with its appropriateness. In that respect, it's important to consider how you construct your statement in support. If you're seeking strikeout, the statement needs to convince the court that even though a less draconian sanction is available, for example, a costs penalty or an unless order, that less draconian sanction would not do justice given the abusive process. So think as you're going along, read and reread your statement in support. It must build a picture which says this abuse is so egregious that strikeout is the sanction. Of course, if you don't manage to do that, you may still achieve a finding of abusive process and obtain a lesser sanction, but a sanction nevertheless, and therefore potentially some costs. And that reminds me, when you're drafting an application, without prejudice to your primary position, you should include as a strict alternative that you seek some other appropriate sanction, depending on the type of claim or the default which has taken place or the stage of the proceedings, and you'll be best placed to know what that is. Of course, if you don't want to dilute the force of your application at all, you should at least make clear when you're instructing counsel that they are to have it as a fallback. If they're worth their brief fee, they should be doing that anyway. But if you simply seek strikeout, the court may find that there was an abusive process, but determine that no sanctions should follow, and you will have failed on your application. Now, that's unlikely. Ordinarily, if an abusive process is deemed to have taken place, the court will impose a sanction. But just take care. I'm of the view that it's best to be robust and comprehensive, and to be clear, at least in your instructions, that there is to be a fallback position sought. Of course, if you're resisting the application, you also have to have this discretionary aspect of the test in mind, and care must be taken not to detract from your primary position that there is no abusive process, while also covering your back in the alternative that should the court find that there was an abuse, plainly this sanction of strikeout is far too draconian, it denies access to justice, and a more proportionate sanction should be considered. Now, as I said, that's a fairly quick run through of that second aspect. It's quite straightforward, and it's each party's prerogative to include within the statement in support of your application facts and matters which would persuade the court to exercise its discretion in their favour. It's frequently overlooked on both sides, with the focus understandably, but wrongly, just being on the abusive process. Before we go on to consider this slightly meatier question of the abuse of process itself, as a brief early interlude, there are some basics which I think are important to get right. First, what do we mean by a statement of case? By definition, it is straightforward. It's a claim form, particulars, defence, part 20 claim, reply to defence, part 18 further information. But while that's quite a straightforward definition, with respect to the judicial approach tends to be fairly sloppy. And in my experience, orders tend to read that the claim is struck out. Now, properly speaking, that cannot be accurate. Under CPR 3.4, it's the statement of case which should be struck out, not the claim. Rarely, and I mean rarely, very rarely, this can give rise to tension between CPR 3.42b and CPR 44.15, because under 44.15, it refers to the disapplication of qualified one-way cost shifting, where proceedings have been struck out as being an abuse of process. It's not unknown, I say it's rare, but I've seen it, it's not unknown for claimants' counsel to argue that the proceedings were not deemed an abusive process, the particulars were, or similar. While that is obviously and clearly primarily wordplay, and any judge should be alive to that, if you're seeking a specific order and it's important to you, and the disapplication of quox, for example, is important, just take care that the order records the wording that you particularly need. So let's go to the first and altogether more wholesome question of what is an abusive process. The blessing and the curse is that there is no set definition. Often we like to work within a definition because it gives us reference points, but the boon of that is the flexibility that it offers. The description offered in the White Book is using that process for a purpose or in a way significantly different from its ordinary and proper use. That is about as clear as mud. A textual reading of it is probably going to leave you staring at the screen a little bit like our friend Goofy here. It doesn't give you anything to pin your hat on as far as I'm concerned. So it's much better to focus on categories of abuse. And if you're fixed with a scenario that you think may be an abusive process, the best place you can start is the White Book at paragraph 3.4.3. I'm going to touch on those categories which are more prominent. And the first of those to consider briefly is vexatious proceedings. I'm not spending a lot of time on this one because it's very rare. It's rare because the abuse is so obvious. It's where there are concurrent or serial proceedings dealing with the same thing. And here the court may strike the claim out and also make a civil restraint order under CPR 3.11. In rare circumstances, it's worth noting a claimant might be able to show that there's a justification for commencing concurrent proceedings. For example, there may be jurisdictional issues. So plainly, a dialogue with the claimant is to be encouraged before jumping to any conclusion. The next category, far more common and far more controversial, is that of res judicata. It is said to be an umbrella term encompassing cause of action estoppel, issue estoppel, and Henderson and Henderson. As to the former two, cause of action and issue estoppel, it's very easy to get caught up in definitions, and before you know it, you're knee-deep in authorities and absolutely none the wiser. I prefer to keep it very simple. Cause of action and issue estoppel are strict doctrines, but for those doctrines to operate strictly, subsequent proceedings have to involve the same parties or their privies, and there must have been an earlier decision by a court on the merits. They are your starting block questions. Are the same parties involved? Was there a final decision by a competent court on the merits? Now, cause of action estoppel simply means that once a cause of action has been held to exist or not exist, that outcome may not be challenged by either party in subsequent proceedings. Issue estoppel arises where a particular issue, which forms a necessary part of a cause of action, has been decided and the same parties are involved in subsequent proceedings with a different cause of action, but the same issue is relevant and a party seeks to reopen that issue. From that, I hope you can see they are very much Ronseal. They do what they say on the tin. They prevent a cause of action or an issue previously decided between parties being raised again by those parties. The bar is very much absolute if that is the case. Only if fraud or collusion is alleged will there be any scope for setting aside the earlier judgment. Where it can start to get slightly more obscure, however, is where there are materially altered circumstances, and there would potentially be an injustice by a party raising the plea of res judicata as an absolute bar when circumstances have changed. Here, the absolute bar is slightly softened, and the Supreme Court in Virgin Atlantic Airways and Zodiac Seats, a case of 2013, a must read. It sets out there clearly as it can be set out. I'm not going to read it out to you. The summary from paragraph 22 is on the slide there. What I would say is if you're in any doubt when dealing with a particular case as to whether cause of action or issue estoppel could be raised, I really would urge you to read Lord Sumption's judgment in Virgin Atlantic, particularly paragraphs 17 to 26. The nub of it is that the bar remains absolute in relation to the cause of action and the issue, and all points which could with reasonable diligence have been raised going to the action or issue. But if there are materially altered circumstances and injustice would be caused, the absolute bar in relation to issue estoppel is softened. That's what you get. Read carefully paragraph 17 to 26. It is a very tricky area of law, but paragraph 17 to 26 do substantially clear it up. And as I say, if you're faced with a circumstance where you're just not sure, you're caught and a little bit undecided, read that and it's very likely that your situation will be dealt with. And that slight softening at the edge of cause of action and issue estoppel segues quite nicely, I feel, into the third and most common branch of res judicata, which might properly be said not to be res judicata at all, but an extension of it. And that's the principle set down in Henderson and Henderson. And who doesn't love a rule of law back from 1843? It's a broader consideration, not confined to the strict remit of cause of action or issue estoppel, and it's addressed at matters which were not raised and decided in previous proceedings. Thus, estoppel in the strict sense doesn't apply, but which should have been raised. If you're interested, very briefly, it involved a decision which was made by a colonial court in Newfoundland relating to monies owed under the terms of a will. In today's money, that dispute was worth about £2.5 million. and having obtained judgment in Newfoundland, the claimant sought to enforce it here in England. And in those English proceedings, the defendant raised allegations of irregularity in the previous proceedings, but significantly he raised new claims that he was in fact the one who was owed the money, but he hadn't advanced those claims in the Newfoundland action. And Sir James Wigram refused to allow the new claims, and he gave us the quote which is on the screen there, where a given matter becomes the subject of litigation in and of adjudication by a court of competent jurisdiction. The court requires the parties to that litigation to bring forward their whole claim and will not permit the same parties to open the same subject of litigation in respective matters which might have been brought forward as part of the subject in contest, but which were not brought forward only because they have from negligence, inadvertence, or even accident omitted part of their case. More recently, Lord Bingham reiterated that this isn't res judicata in the narrow sense, nor is it cause of action or issue estoppel, but it's a rule of public policy, and it's based on the desirability that litigation shouldn't drag on forever. And the general interest, that general interest as well as that of the defendant, that there shouldn't be successive suits when just one suit would do. You can see from that, I hope, the breadth of it. It's not confined just to adjudicated matters. It's not confined to the matter being between the same parties even. It's significantly more flexible, but it's directed at the same matter of policy. Probably the most helpful summary of it is from Lord Bingham, again, case of Johnson and Gore Wood, which is another must read. I've given you the quote on the screen there because it's the quote that is torn apart in abusive process hearings. If you ever do an abusive process application, this is what the court will inevitably be taken to, and it's important to consider it carefully. I'm not going to read it all out, but the highlighted parts are that the underlying public interest is the same, and when he says the same, he means the same between cause of action and issue estoppel and Henderson abuse. There should be finality in litigation, and the parties shouldn't be vexed twice in the same matter. That's the same public interest. The bringing of a claim or the raising of a defence in later proceedings may, without more, amount to an abuse if the court is satisfied that the claim or defence should have been raised in the earlier proceedings if it was going to be raised at all. And the burden will fairly obviously be on the party who's alleging that. However, there will rarely be a finding of abuse unless the later proceedings involve what the court regards as unjust harassment of a party. The distinctions also made between a matter which could and a matter which should have been raised. The court there took the view that that was too dogmatic to say that because it could, it should have been raised. It should be a broad merits-based judgment which takes into account the public and private interests involved. So what does all of that mean to you? Well, plainly, it's necessary for the alleging party to show that the claim or defence should have been raised in earlier proceedings. Now, the difference between should and could is often seized upon by the resisting party, but that is to misunderstand the context of the comment as far as I'm concerned. Much of this case law is developed in the context of multi-party commercial litigation or cross-border litigation. There you can foresee legitimate reasons why some claims may not be brought in, why a party, for example, with a valid additional claim might decide to leave it out of that set of proceedings. And the issue might be more finely balanced in that remit of broad commercial multi-party litigation. But where you've got a limited number of parties, especially where there's one claimant, one defendant, one subject matter, considering that the very point of the rule of law is that parties should bring all of their case in one go, should is not a high hurdle to overcome. The next consideration is whether there is unjust harassment or oppression. Again, parties resisting findings of abusive process will inevitably focus on this, and they will say that absent some overt harassment or oppression, it cannot be abuse. Now, I don't agree with that, or perhaps better, I should say, I don't generally agree with what is categorized as oppression or harassment. And I think it's wrong to shy away from applications on that basis. It comes back again to this distinction between complex multi-party litigation on the one hand, where a party could properly and rightfully say, well, the other party hasn't been involved in any of the previous litigation, barely been involved at all, not been harassed, it can't be Henderson and Henderson abuse. Of course, I can get on board with that point of view, but if you're dealing with the same parties and the same or a similar subject matter, I take the view that there is an inherent harassment or oppression in raising a new matter after the former matter has concluded. The harassment is intrinsic in the fact itself of pursuing the same party again. There's harassment there in respect of time spent, the costs incurred, closing down of systems or inquiries, and the knock-on effect of handling other business, and so on. They are the things that you should be focusing on in your applications, the impact of the matter being raised again, or the lack thereof. Frequently, I'm faced with the judge saying, well, that's all well and good, Mr. Ferguson, but tell me what the prejudice is here. So when you're drafting a statement, don't just focus on what the offending party has done. Don't just focus on what you say is the abuse. State the prejudice to your client in black and white. There's a helpful 6-point consideration given in the Aldi Stores case, which again is repeated in the White Book. It deals with the issues of how many parties there are. It deals with the distinction between could and should, harassment and oppression. It's taken from Johnson and Gorewood, and it's a useful framework for you to have when drafting an application to guide your statement. And actually the comment, which is on the bottom of the slide there from Lord Justice Clark, goes directly to what I've been saying. It goes directly to the harassment, the oppression, the could and the should. It's quite one thing to say that A should bring all of his claims against B, and quite another thing to say that he should bring all of his claims against B, C, D, and E. That's because in Aldi Stores, the defendant there hadn't been involved in the first action at all, and that was what was deemed to be a commercially reasonable, forensically legitimate, and reasonably transparent decision. And the defendant was facing the claim for the first time. So that there is largely a repetition of what I've discussed, but it's a helpful summary of the principles which you should consider. You will need to distinguish your case from that scenario and show why this isn't fresh to your client, why there's no good or legitimate reason to be dragged into litigation again when it should have been dealt with the first time around. So remember, this is a broad merits-based judgment, taking account of all the public and private interests and all the facts of the case. That means you should not be asking the court to exercise its discretion in finding abuse of process. Discretion is only relevant to the decision to strike out, to that second question. That's a really important point to remember. It's a broad merits-based judgment. You could well be, if you obtain a finding of abuse of process based on the court's discretion, you could well be faced with an application to appeal that decision, and it would have some merit. Also to note, the broad merits that we talk about there in terms of the broad merits-based assessment doesn't refer to the substantive merits of the claim itself, but to the merits relevant to the question of whether the claim should have been brought as part of the earlier proceedings. You might have noted that I referred to the matter having concluded, and that's because Henderson and Henderson arises where there has been settlement as well, not just where there's been adjudication. And that's important to remember. It's no less abusive because the parties settle the initial claim. So while res judicata might not apply in the strict sense, the principle in Henderson is of assistance. And as I've repeated on numerous occasions now, it's directed at the same matter of policy. The final and interesting point to make in respect of Henderson and Henderson abuse of process is whether the rule can be used when you're resisting an application to amend under CPR Part 17. The court's power to allow an amendment to introduce a new claim is discretionary, which obviously sits at odds with Henderson abuse of process not being discretionary, as I've just reiterated, but being a rule of law. So for some time that had appeared to be the case, and the courts took the view that Henderson and Henderson wasn't applicable. But then in the very, very recent decision of Kensal and Corey, Mr. Justice Saccaroli took the firm view that Henderson can apply, notwithstanding that the principle in Henderson is directed at subsequent sets of proceedings as opposed to amendments within the same set of proceedings, and notwithstanding that the court has a wide discretion anyway under Part 17. You can see the quote there on the screen. He says, "So far as the point of principle is concerned, I do not see why the existence of a broad discretion in the context of an application to amend is a reason to preclude altogether the application of the Henderson principle within the same action. A finding that a new claim would amount to an abuse of process must lead to the claim being disallowed as a rule of law and not merely an exercise of discretion." So just bear that in mind. If you're dealing with a late application to amend, there is the potential to raise the principle of Henderson as an abuse of process. I would say the later the amendment, especially if it comes after an interlocutory decision, the more likely the court is to entertain your application. So there you have it. Henderson and Henderson is a broad merits-based decision for the court, taking into account the interest on both sides, but upholding the important principle that a party shouldn't be vexed twice in the same matter. The next category to look at is where a set of proceedings terminate without substantive adjudication or settlement. Res judicata and Henderson don't apply here, but you may still be able to have a subsequent set of proceedings struck out as an abuse of process. There are a series of cases which it's necessary to consider briefly. First, Securum Finance and Ashton, where a claim was struck out because of inordinate and inexcusable delay. There, the Court of Appeal held that the second bite at the cherry sought by the claimant had to be weighed against the overriding objective. In particular, there, the limited allocation of court resources. The conduct was deemed so serious that it amounted to an abuse of process, so if a second set of proceedings were to be justified, a special reason would be needed. Then in 2001, we had Collins and CPS Fuels, where the first claim was struck out for a failure to comply with an unless order, but there were numerous other failings, none of which were intentional, but no good reason was given, and the failures were inexcusable. Then in Cranway and Playtech 2008, there was a slight tightening and the second claim was not struck out. A broad view was taken there where the stage of strikeout of the first action was relevant, and the failing, while leading to strikeout, had been in relation to the requirements of a pleading only. All of it led to the need for some cohesion clearly, and it culminated in Davis and Carillion Energy Services in 2017. And this is what you should really be looking at if you're faced with the potential for an abusive process where there's been no substantive decision on the merits. A litigant in person here began litigating in 2010, and that claim was struck out for failure to file and serve particulars of claim pursuant to an unless order. There was no appeal, no application for relief, and then the second set of proceedings were brought in 2015 against the same defendant. The application to strike out as an abuse was dismissed, and that decision was upheld on appeal, and guidance was given for cases where the first action is struck out on procedural grounds without a consideration of the merits. The distinction here is clearly drawn between cases where the first action is struck out as an abusive process. If the first action is struck out as an abusive process, the second action will be struck out absent special reason, which is akin to very unusual circumstances. If the first action is not struck out as an abuse, the second action might still be struck out, but the particular circumstances of the first action being struck out must be considered carefully, and the court must view the conduct in the first action as, at the very least, inexcusable. So for you, that's the important distinction to draw when you're considering a second action following the first one being struck out on procedural or non-substantive grounds. Consider the facts carefully. Obviously, if the first action is struck out as an abusive process, the claimant will have a mountain to climb to persuade the court that the case falls into the category of very unusual circumstances. If it hasn't been struck out as an abusive process first time around, think carefully about how you can categorise the conduct as inexcusable. That's going to require a factual analysis of the claimant's conduct. A single failing to comply with an unless order isn't going to be enough, but if that can be combined with other conduct, then it may be enough. So any application is going to have to spell out to the court why you say the conduct, even if that is a single failing to comply with an unless order, why that conduct, compounded by other conduct, is inexcusable, or if you're resisting it, is not inexcusable. You have to paint that picture. Don't expect the court to infer it simply from the first matter having been struck out. Finally, from Davis and Carillion Energy Services, we're told that the assessment of the claimant's conduct should be rigorous and in the defendant's favour. But note the rider that the overriding objective, the overriding need to do justice will trump the efficient use of the court's resources. So there's a slight rider that simply saying that this is an abuse of the court's resources, the court's overburdened, that's not going to be enough to overcome the overriding need to do justice. The next category is pointless and wasteful litigation. Here the burden will be on the asserting party that the benefit which the claimant seeks is of such limited value that, the quote is given, the game is not worth the candle, and the cost of the litigation will be out of all proportion to the benefit to be achieved. The important message is that just because the value is low or potentially even nominal, that itself will not make this an abuse. Rather, the category here of pointless and wasteful litigation is directed primarily at litigation where it's being pursued not to vindicate a right, but to cause expense or harassment beyond that which you'd normally expect in litigation. Fairly obviously, the burden is going to be on the defendant. So in other words, if a defendant considers the claims being brought or pursued just for nominal gain, at disproportionate expense and time, for no substantive reason or any real value other than to be wasteful and difficult, the defendant needs to prove that on a balance. A brief example is the case of Jamil, a libel case where the publication in that case was very limited, damages were therefore limited, and the claim was struck out. While there would have been, in that case, some limited vindication, so some merit, as Lord Phillips put it, the game will not merely have been worth the candle, it will not have been worth the wick. At paragraph 54, the quote there, an abusive process is of concern not merely to the parties, but to the court. It's no longer the role of the court simply to provide a level playing field and to referee whatever game the parties choose to play upon it. Now, something to keep an eye on is that a case might not be considered pointless and wasteful when it starts, at its commencement, but during the course of litigation, it might become exactly that. So be mindful of any inference which might be drawn as the case proceeds. Again, for example, in the case of Adelson and Henderson, it hadn't been an abuse when it was issued, but it had had a slow start and then it went to sleep for 3 years. And so that resulted in the inference being drawn that the importance had diminished. And in that case, then it was struck out. Finally, to mention Jamil, the case I referenced earlier, was reconsidered, albeit obiter, by the Court of Appeal in 2012, with Lord Justice Lewison putting there a particular emphasis in respect of the proportionality of the procedure to determine the claim. So for you, if you're faced with a case which you think at first blush looks pointless and wasteful, the first issue you need to address is whether there will be a procedure for determining the claim that can properly be categorized as proportionate. If there can't be, it's going to be completely disproportionate to go through the mechanics of litigation to achieve such tiny gains, such meritless objectives, then make your application. A similar matter, another category is delay, another category of abuse. However, the important point to note here is that delay, even if the delay is long, by itself is very unlikely to result in a finding of abusive process and strikeout. You need to categorize the conduct more broadly as abusive, part of which can be that delay. So you need to look for example, general disregard of the rules within which there is a long delay. For example, the case of Habib Bank and Jaffer, a claim was struck out where the delays were caused by the claimant acting in wholesale disregard of the norms of conducting serious litigation. And the claimant did that with full awareness of the consequences. So it wasn't just the delay, which was very long, it was a wholesale disregard for the rules. For example, in this regard, issuing and maintaining proceedings with no real intention of carrying them through to trial, something which is known as warehousing, that may amount to an abuse, but the court's always going to have to examine the circumstances, including the length of delay, the degree of the claimant's responsibility for that delay, and the reasons given for it. And all of that is, we're told, an objective assessment. The court will stand back and look at it all objectively. So note here that a delay, even a long delay, can't be categorized as an abusive process without some additional factor which transforms it into an abuse. If the claimant is represented by competent solicitors, ignoring correspondence, failing to respond to calls, things that I'm sure you're all very familiar with, demonstrate them in your witness statement. Exhibit call notes, emails. That might be sufficient then to turn the conduct into an abusive process if you can provide black and white. It's not just been a delay, they've consistently ignored our correspondence. Next category relates to pleadings themselves. There may be here some overlap with CPR 3.42a and the statement of case disclosing there are no reasonable grounds under CPR 3.42a, but also the court may strike out as an abusive process in its own right particulars of claim which are so badly drafted that they fail to reveal to the defendant or the court the case the defendant can expect to meet at trial. Note here, however, that just proof of bad drafting won't by itself be sufficient. The court's not going to strike out a particulars without first giving the claimant an opportunity to amend. So strikeout might be appropriate here where the court can be satisfied that the claimants have made it clear they've got no intention of trying to amend or to put forward a coherent and intelligible claim. So if you receive a particulars that makes little to no sense, as I'm sure many of you have, invite the claimant to amend. If they refuse or if they just ignore you, you're much more likely to exceed on your application at the first time of asking. You can say there's clearly no intention to put forward a coherent claim. Otherwise, you're probably only likely to obtain an unless order. So that's a fairly quick whirlwind through the various categories of abusive process, those which are most prominent, which crop up most frequently. But finally, a few points to note. Make your application under 3.4 as soon as possible, and if you can, before allocation. Generally, the sooner that you get your application in, the stronger your position will be that you consider there to be an abusive process. It's fairly logical that it becomes harder to maintain that when you ignore an abuse for a long period of time, it's still an abusive process. You've got to be prompt with your application. Practice Direction 3A refers to Part 23, so your application, as I've said throughout, should be made with supporting evidence in the normal sense. And I would stress that the application shouldn't be burdened with legal argument. Of course, that should be the case in any event, but frequently applications take extracts from case law, principles, and read more like submissions or a skeleton argument. Just focus on the evidence, on the prejudice particularly, demonstrate it in black and white, exhibit emails and exhibit correspondence. I find that frequently the courts are willing to entertain an abusive process finding and a draconian sanction of strikeout, but they want something to pin their hats on. They want to be able to say, here is where we can say there is particularly egregious conduct demonstrated in black and white. In addition to that, I always take the view that you should give prior warning. It's much, much easier to convince a judge, a court, if you're able to say we give prior warning that we would be making this application and the abuse was maintained or not addressed at all. So give that prior warning, give sufficient time, but then make your application promptly. I would strongly encourage that the category of abusive process be defined briefly. For example, wasteful litigation, Henderson and Henderson, or poorly drafted pleadings, with the focus and then the body of the statement in support, focusing on the facts and the prejudice. Equally, I would, if you're dealing with an application of this nature, I would recommend when you're instructing counsel to require a skeleton argument and that it reaches the court well in advance. It makes any application of this nature, because it can be quite legal and technical, it makes it much, much easier to present if counsel has provided a skeleton argument in advance. So that's it really on abusive process and strikeout applications. Thank you so much for your time, for joining and for listening. I'm going to take a moment now to see if there are any questions on the Q&A tab. Give me one moment if you would, while I just consider that. If you do have any questions, I'm just drawing the screen up. You can pop them on the Q&A. I don't have anything. You're more than welcome to send any questions into Chambers if you do have any, and I'm sure they can be forwarded. All that it remains for me to say is thank you so much for your time, for joining this webinar. As I say, it will be available on the Chambers website at the knowledge base tab. It might take about 24 hours from now for it to go up there, but it will be there with the slides. And if there's anything further from that, please do just give me a shout through Chambers. Thank you so much for joining us.